Hey, good morning, everybody. Welcome back to Law and Legitimacy. I know you missed us yesterday because we missed you. Where were we yesterday, Mike?
Yesterday, we were in the Guilford County District Courthouse. That's where we were.
Doing what?
Making a first appearance on behalf of a client in the ABC world. You know, Norm, I think I've talked to you about this before, but it's an interesting development in the North Carolina side of things. You know, I do ABC work. I'm traditionally regarded as a transactional attorney. I work with the regulatory stuff. And in the rare exception where, you know, litigation juggernauts come knocking to see if I want to sit second chair while they do windmills and 360 dunks in front of, you know, federal court judges, I typically do not litigate. However, the nature of my practice is changing kind of, you know, right before my eyes, and that is because it appears as though North Carolina law enforcement agencies are now using a pretty underhanded approach to combat the policing struggles that have been driven by the bad optics, right? And we're going to talk about some bad optics for law enforcement today in another context. But what I mean, just very at a very basic level, is an ABC permittee in North Carolina is subjected to a host of regulations and statutory requirements. But at all times, a permittee, as they're known, is understood that their behavior is policed by the North Carolina ABC Commission and the processes set forth in the administrative hearings and the offers in compromise and settlement negotiations that occur in and emanate from Raleigh. What I'm finding, Norm, is that my clients, the permittees, the agents on behalf of the permitted businesses, are being charged in their personal capacity criminally pursuant to these statutes that attend to the business conduct arising out of the business. So going to have some fun with that in the next couple of months. Really just deciding on strategy. I don't like the ABC any more than I like, you know, the ADAs. So just kind of choosing the lesser of all evils here.
Well, welcome back. You know, I mean, I'm a courtroom lawyer, not much on the business side, as you know, privately. But you know, well, have fun in court. There's no such thing as a bad day in court. There might be bad results, but court is always interesting. So the defense is rested in the Donald Trump case, and much to my surprise, Donald didn't testify. And it showed me for the first time in a long time that the guy has got an end game and he is capable of listening to counsel. I would have placed decent money on his testifying, on the theory that he wouldn't be able to stay away from that stage, and that any confrontation he would have with Judge Merchan, he would attempt to turn to his advantage in a political way. But I think that he was wise not to testify. I think that Judge Merchan would have limited him seriously on his right to testify. I think there was a substantial likelihood that if Donald continued to narrate in the way that he saw fit, Judge Merchan might have held him in contempt. And whether that would be good for the brand, the Donald brand, or not remains to be seen. But I think he was wise not to testify. I also was puzzled by a decision that Merchan made when dealing with the testimony of a former Cohen lawyer named, I think, is it Costello? Am I getting the name right?
That's right.
If press accounts are correct, Merchan may have handed Donald a mistrial. Apparently, Costello got on the stand to testify. He's a former lawyer for Cohen. And somehow, I'm not sure how, candidly, because I'm not in the proceedings, not reading transcripts, but somehow Cohen's former lawyer got on the stand to testify about his communications with his client and his former client, and characterized his former client as a liar. And was permitted to do this absent some finding of a waiver. The attorney-client privilege typically cloaks a communication between a client and a lawyer. You don't have to pay money to have an attorney-client privilege. Many times people will say, I want to talk to you. I want some legal advice. Here's $1. You're retained. That's not there. There's no magic retention test in the law. The law is that if a person seeks you out for your legal advice or expertise and confides in you, their confidences are sacrosanct. And there it is. But so there was Costello on the stand. And Costello got openly defiant of the judge, according to reports in the New York Sun and other places, as objections were sustained to some of the narratives that Costello was offering. He'd roll his eyes. And at one point, he even got in a, quote, stare down with the judge. And the judge called him on it. He said, "Are you staring me down, Mr. Costello?" And this then was the moment where Mershon, who I have been largely supportive of in this trial, may have gone off the reservation. He admonished Costello, but he did more. He threw the public out of the courtroom and threw the press out of the courtroom so that he could dress Costello down and tell Costello that if his antics on the stand continued, he would not only remove him from the stand, but strike his testimony. This business of removing the public from a active trial is a highly significant event, especially in the Second Circuit, which is the Federal Court of Appeals that governs New York. There is a case, and I can't recall its name, where years ago during jury selection, United States Marshals directed a client's family to leave a courtroom during voir dire. They needed the extra seats for jurors. That was held to be a violation of the First Amendment and of the Sixth Amendment right to a speedy and public trial. And that act alone was sufficient to require a reversal of the proceedings. So what we have with Mershon is an active and controversial witness on the stand, a witness that apparently had contempt for the court and expressed that contempt in facial gestures and whatnot in the jury's presence. And Judge Mershon felt, I guess, offended by that. And he threw the public out to admonish the witness out of the jury's presence and out of the public's presence in such a way that the juror or the witness was told that if he kept it up, the testimony would be struck. Question number one on appeal is whether that move deprived Donald Trump of his right to a speedy and public trial as guaranteed within the Sixth Amendment. Question number two is whether that move alone deprived the press and the public of its First Amendment right to attend a judicial proceeding. There is simply no justification that I'm aware of under law for removing the public from that proceeding. I can see getting the jury out of the room. You know, you don't want to prejudice the jury. You don't want to poison the jury. You want to admonish a witness outside the jury's presence. I've seen that happen all the time. But I have never, in 30 plus years of trial experience, seen a judge remove the public from a courtroom to admonish a contemptuous witness. The closest I've seen to public removal from courtrooms occurred during the Proud Boys trial. And this happened repeatedly when issues involving confidential human sources needed to be aired in ways that presumably protected the government's interest in sources and methods of gathering information. There was another occasion in the Proud Boys trial where we learned that the government had mistakenly disclosed national security material to the defense. And to air that out, the public was asked to leave the courtroom. There was also an occasion where some sensitive information was being shared about a juror and questions about whether the juror was capable of remaining on the panel throughout the proceedings, where that was done privately. In each of these cases, there were important interests that the government and the court sought to protect: national security, sources and methods of how the government operates in sensitive investigations, and confidential information about a juror. I'm not saying that I agreed in any of those instances that the public should be kept out of the room, but at least I could see a principle at work and a principle that I could articulate and understand. And I'm evaluating the issues to be raised on appeal in the Proud Boys case now. Whether any of those issues make it to the appellate room, the appellate court is an open question and will be for many months. But in the Juan Mershon case, I see zero justification for removing the public from the courtroom. And so I don't think Juan is a deep state clone. I don't think he's a political hack. I don't think he's a crony. I think he's a judge trying a case under the law as he understands it. And like all human beings under pressure, sometimes he gets it right and sometimes he gets it wrong. In the case of removing the public to admonish Costello, Mershon was dead wrong and perhaps fatally wrong. That might have been one of the most significant decisions in the Trump trial, and I expect it to be front and center of an appeal should Donald Trump be convicted.
Yeah, and I think that's why I asked how bad a move was Mershon's outburst, even to even to the detriment, I think, of our rapport with many of our viewers and subscribers. You have been fairly neutral as we've covered this case. And it's interesting that we can point at this as sort of a seminal moment. I think that across the partisan divide, this is an issue, sending the press out of the courtroom in that instance. And we're talking about at the ass end of this case, right? I mean, this is an amazing sort of unforced error. I think about, the 93 Michigan Fab Five moment when Chris Webber looks at the sideline to call a timeout and they don't have any more, right? And here comes Donald Williams to the stripe for the technical foul shots to win the title, right? This is that kind of move, in my opinion, just totally unforced error on his part. And you've said over and over, and something that I've internalized, Norm, is that the judge is supposed to be the referee, right?
No, that's right.
And to the extent he has been an object of criticism throughout this process, I can understand why, right? I think that's easily understood. However, in this instance, the unforced error is making himself a part of the proceedings in such a way that is material to the outcome.
Yeah, no, I hear you, and I think that's right. I mean, I'm looking at some of the comments, about the judge that are coming in. I guess it's off the is it the YouTube stream that I see here? Yep. And I want to fess up to folks about my attitude toward judges. I know that many of you have concluded that I am naive and perhaps unreliable as it comes to reporting on high profile cases because I am a toady for the judges. Here's a confession. I have been involved in thousands of court proceedings, more than probably 500 appeals, hundreds of trials. I'm going to court today after this broadcast, and not once in my political career, and I'm talking about a career that has spanned cases from the United States Supreme Court on down to the most insignificant small claims court pending in Connecticut. Not once in my career have I paused even for a nanosecond to consider who appointed a judge before I went to argue my case. That strikes me as the coward's way out. A lawyer's responsibility is to argue his or her case according to law. And what that means is you understand your client, you come to understand your client's interest. What is it that they're seeking? What is it that they're protecting? What is it that they want to accomplish? And then you identify the law that supports their position. You identify the law that is antagonistic to their position, and you do your best to advocate for your view of the law. I don't get up in the morning and say, I'm in front of a Trump appointee today. I'm in front of a Clinton appointee today, because my experience of the judiciary, especially the federal judiciary, is these are lifetime appointees who may have ideological commitments that they brought with them to the court. But the benefit of a lifelong appointment is that their only obligation is to get it right. And that is to build a coherent body of law that will hold the country together throughout its divisions and turmoil. So, those of you who want to politicize every judicial decision, go ahead. You just won't find an ally in me. I view that as tedious.
One thing, Norm, and so thank you, Luttrell, for that comment. And I'm sure that with time we can go and review that video. But here's something that I think we do need to address, and just based on several comments we're getting. So I'm put Jules' comment back on the screen here. Norm, could you comment on Mershon's daughter and possible conflict of interest? And before you do, we've got others in the Rumble stream who are asking the same thing. MDMA says the judge is politically compromised. Jackson Barrett, the money in politics is corrupting influence. And one thing that I think sets the foundation for the overwhelming and very, I guess we could say, salient credibility issue for Mershon in this case, and I think sets us up for, in particular, you. I think I'm probably warmer to the notion that this judge is more probably than not politically compromised. But this is an issue that has been raised before and is coming back around, so to speak. So I mentioned before that Laura Loomer was really the first that broke the news of Mershon's daughter's political activism on behalf of the Democrat Party, and she hasn't really gotten very much credit, to my knowledge, for having done that. But that is a story that she broke months ago that has really been nurtured.
Is it a story though? I mean, how old is the daughter? Are we, I mean, my understanding is Mershon has an adult daughter who is active on behalf of the Democratic Party or the Democrat Party. My understanding further is that over time, Mershon has made some nominal political contributions to the left, to parties identified on the left. And these are so whats as far as I'm concerned. I
Well,
mean,
and
if
I think
Mershon's
that that's
daughter
why.
is an activist, does this mean that he can't sit on any case involving a Democrat?
No, but
I
I
mean,
do think that this is part of the, so what Don is saying here, and I think the atmosphere that this all exists within is tainted in a way that is difficult to unwind, I think is the problem, right? So everything that's under a microscope for Judge Mershon, and again, we don't have cameras in the courtroom in New York. This is something that we talked about um, with the gag order that was issued, and the fact that we can't really see what's going on in here. All of this is having to be reported. The In combination with the fact that this is not televised, this is not available for public consumption, and then he sends out the press at this odd moment toward the end of the trial, sort of, again, that sort of unforced error. It just, I want to take a moment just to give some light to the fact that the people who have been really steaming up this issue of his potential bias, Norm, I do think that it's reasonable. That perspective to me is entirely reasonable. And to the extent you haven't looked for who appointed what judge in your career, I think that point well taken. And I think that level of accountability, that extreme ownership, as it were, is important for anybody in your position or even in my position. But over the overarching sentiment here is that this trial has massive implications for the future of the country. This morning, I was just thinking, I know this is a bit of an aside, but we are in desperate need of someone with a unifying voice, right?
we
And
are. And
my hope with Trump is that, given all of this, this rising tide, this swell of support that he's getting for people that really look at the institutions and say, like we have, that there is a crisis of legitimacy within these institutions. There are corrupted political influences, et cetera. You know, is he able to stand up to the task once he is elected? That is a question that now I'm just saying it out loud, but it's something that has been bubbling in the back of my mind, that there is so much buildup to this moment come November. What are our expectations for a second term Trump presidency on the other side of these sorts of what some people call show trials, what you and I have really analyzed on the merits, right? What is his president? What is his promise of presidency? So anyway,
well, that's a couple steps beyond where I am right now. I'm looking at customer states PNW agreed, Dawn, to my question many shows ago to Norm still persist. When does this become coordinated electoral election interference? You know, I don't know what election interference means in this case. I view this as a use of prosecutorial power. It was not able to be stopped as vindictive or selective prosecution. There was no claim of executive or candidatorial privilege such that the prosecution could be stopped. The prosecution was maintained under the theory that no one is above the law, and that Mr. Trump could continue to run while being prosecuted. I find these unremarkable. I might not have endorsed the decision to prosecute Trump as having political consequences that are untoward. And that is a political judgment that prosecutors make. And they make them all the time. And so, the decision about when to prosecute and how happens in matters large and small. I simply think that the quick reaction to attack the courts and attack the court officers reflects a broader crisis of legitimacy. And I'm not that far down the rabbit hole yet. Many of our listeners are, and I look crushingly naive for the positions I take on that. And that may be simply an occupational hazard. I go to court every day, as I will go to court to argue a bond motion on behalf of a client within 45 minutes of the ending of this stream. If the bond motion is denied, I'm not going to decry the politics of the judge or suggest that one of the parties was out to get my client. Now, my client is a political unknown, but his interests are very real. And I'm going to argue his interests according to law. And I'm going to argue it to a judge who I assume is going to decide that case according to law. If I think the judge has untoward influences, or if I think the judge is unfit, I'll attack the judge and seek to have the judge disqualified. If I lose that ruling, I'll take an appeal. If I lose that ruling, I'm left with nothing left but the judge and the law. And I think respect for the judicial system means respecting outcomes, trying your case. And when you lose, not being a sore loser and blaming the system and try to crash the republic, but move on to the next case, because, our judicial system is not perfect. But I'd challenge someone to design a better one. And I realize that makes me sound like a flag waving harpy, which I'm not. I am a deep critic of a lot of what goes on in the courts. Justin Wright calls it idealism. I think I'd call it bloody realism. I've been to court.
Bloody realism. Bloody.
I've been to court this weekend in murder cases, in rape cases, in robbery cases, where the interests that my clients maintain in liberty could not be more significant, when the losses sustained by victims could not be more real. And the place I'm going to advance our collective well-being and to balance the rights of my clients against their responsibilities to society and society's right to protect these things are courtrooms. And I grieve when I see an easy and cynical attack on the courts as suggesting there's a better way to resolve our problems. And if it's the street, I don't want to be part of street justice. But having said that, let's talk about Scottie Scheffler, because there are cases that do make you wonder just what's going on. Donald Trump's really isn't one of them. Tell us who Scottie was having a great year. What's up?
Yeah, he's widely regarded as the best golfer in the world. He's almost as good as I am, but he won the Masters.
I thought you were going to say he was almost as good as the Tiger Woods of old,
I wanted your opinion on sort of the procedural posture of this. So, the PGA Championship, Norm, was at Valhalla, and that concluded on Sunday. Friday morning, really early, Scottie, in preparation for day 2 of the tournament, is making his way to the course. And there was an unfortunate incident earlier, like really early that morning. A volunteer for the PGA Championship apparently was crossing the road and did not look and was hit by a shuttle bus and killed. So there was a traffic detail that had been assembled there, creating traffic backups, etc. According to the reports that I'm reading from various different outlets, the golfers who have access passes and credentials and are visible through their vehicles had been, coordinating and had been going around this traffic detail. And according to Scheffler and his attorney, that's also what he was doing. But according to reports, Scottie's going around this traffic detail. There were conflicting. I think that he only understood there to be one, which was, come on, go around. One particularly impassioned law enforcement officer decided that they were going to halt Scottie, and then was, I guess, knocked over by the vehicle or whatever. Pants damaged beyond repair, according to reports. And he has been charged for, a number of things, felony assault on an officer, several other items. He was arrested. He bonded out. He made it for the rest of the tournament. He actually finished 8th overall in that whole field for the weekend, if you can believe that, after all of this. The golf world and I guess common sense minded people have largely gotten behind him. But what became an issue was his attorney's attempt to delay the arraignment for a couple of weeks. And that was really what I wanted to talk to you about in these situations where he's been arrested, he bonds out, he's going about his business. Is it common for, defense attorneys or just parties in general to look for, some sort of disposition or, his first real appearance, to delay that for any amount of time? I mean, he had to go home, I think, to Texas is where he lives full time, because this is in Lexington, Kentucky. So can you talk a little bit about that?
So if anybody wanted to look for an example of what the left calls white privilege in the criminal justice system, look no farther than Scottie
Here
Scheffler.
we go.
No, look, I mean, and I hate the notion of white privilege. I mean, I think that the law should respect all people equally. But here is what I understood, and I have a little bit of a darker read on the events than you do that morning. A volunteer is killed in a collision with a van at around 5 a.m. Scheffler and others are on their way to the course to prepare for the high-stakes business of professional golf. Officers are managing a scene, whether it's a crime scene or not. They don't know at that point. What they have is a homicide, a collision with a vehicle and a citizen, and their objective is to preserve that scene while an accident reconstruction person gets there to make measurements and to do their best to determine physically what the evidence shows happened. Who was at fault for this death? Did the pedestrian haplessly wander in front of the vehicle? Did the vehicle not pay attention? Is it a combination of both? What we have is a homicide, the taking of life by one person of another, and a prosecutor is now going to have to evaluate the facts gathered by law enforcement in order to appropriately charge or not as they see the evidence. That is the classic interaction between police and a prosecutor. So crime scene integrity is drilled into the head of an investigating officer. It's part of every police procedural. You don't want to contaminate the crime scene. You want to manage the public's access to it. Typically, at the perimeter of a crime scene, there's one officer whose responsibility is to identify everybody who enters and leaves, when they enter and leave. If I have a crime scene and I find that somebody has sloppily maintained the perimeter, I'm all over that, like white on rice, especially in a DNA case. Where'd all that DNA come from? People you don't even know? And so we have a tense situation, officers directing traffic, high stakes athletes under considerable tension to get where they need to go when they need to get there. And now you have conflicting imperatives. The police need to get it right. The athletes need to be prepared. Who's in control of the streets at that moment? Candidly, the police officer. The police officer has a right to direct traffic, and Scott has a duty to obey those directions. That's going to yield some frustration. Now, as I read the events, the officer apparently tried to direct Scottie in a certain direction, and Scottie didn't take the direction. The officer stepped into the path of the vehicle or was brushed by the vehicle and had more than $80 worth of damage to his pants. He went to the hospital for some treatment. Scottie was charged with second-degree assault on a peace officer, and that's a significant felony. That's going to put you in jail almost every time. Assault on a police officer means that you used unauthorized physical force, either from yourself, your person, or something under your dominion and control, that is your car, and collided with an officer who was identifiable, performing his function, and you did so without justification. So efforts to pass this off as a simple misunderstanding on Scottie's part, okay, let's see what the defense has to raise.
That's what his attorney and that's what other
let's see, and let's have the trial.
Witnesses are saying is that there were conflicting instructions, that he was being told to come, and that when he stopped. So this is the defense that's at least being portrayed in the press and being reported.
And it may be a valid defense,
right? He did indeed stop, and that's the only way that they were able to get him out of the car and make an arrest. Is that when the confusion or the chaos stopped, he stopped, and there we are.
Or in the alternative, after the officer was injured and all hell broke loose, he stopped, but not beforehand. And he wouldn't have stopped but for the injury. And so, I don't know. I read the story carefully, but the question you asked is the treatment of the arraignment. The Constitution, there are two types of arrest, basically, in the United States. bad
Well,
ones and worse
and
ones.
before you
No,
get to this, I just want to share this. So the officer that was injured and I guess is what catalyzed the arrest was not wearing a body cam. So that's becoming an
fine.
issue as well. So in terms of the conflicting reports, it's just interesting the day in which we live. Here we have one of the golf world's most um, famous and valuable athletes embroiled in what you have qualified as a very considerable criminal legal entanglement, right? Especially
It's
given the
going to be a
charges.
fantastic trial. Scottie, call me. I know all about police force cases. This is
Scotty
going to be
Tuhati, baby, give Norm a
this
call.
is this is going to be a fantastic trial if it goes to trial, because what the public will be given is education about the rights and responsibilities of police officers investigating a crime, the rights or a suspicious death, the rights and responsibilities of members of the public who come upon that, and how these things get investigated. The lack of a body camera, that's going to obviously be a defense theme. And there'll be a suggestion that maybe it was turned off deliberately, this, that. I mean, all sorts of stuff are going to come up. This trial will probably take 3 weeks of evidence just to capture this moment. But the question you asked is the treatment of the arraignment. There are two, and let's focus on that because that's a very simple issue. There are two types of arrests in the United States: on-site arrests, that is, arrests without a warrant, that is based on the direct observations of officers, or in certain circumstances on speedy information given to those officers. There are also arrests pursuant to an arrest warrant, and that is after officers have done an investigation, summarized their conclusion for a prosecutor and a judge, and a prosecutor and a judge signs off and says there's probable cause to believe there should be an arrest. Both on site and warrant arrests are evaluated under the probable cause standard. To protect a defendant, you have a right to a prompt arraignment. And I don't, there's no magic test, but it's a violation of a defendant's right to hold him weeks prior to an arraignment, because he could be held without probable cause. And in this case, for a significant charge, assault second on a police officer with injuries sufficient to send the officer to the hospital, many people would be detained on scene and not permitted to go about their business. And the detention on scene would result in their presentment or their arraignment at a courthouse promptly, so a judge could determine whether there was reason to bind them forward to trial, whether there was reason for a bond at all. You get the impression that Scheffler got the star treatment here, that he was recognized as one of the world's leading golfers, that he was involved in a serious potential crime, and that rather than disrupt the tournament, officials decided to let him play and put off his problems for another day. I think, frankly, that's unfortunate. I think the local prosecutor's office objected to his special treatment, and I think they were right to do so. The court gave him special treatment, and I can't say the court was wrong to do so. I mean, he is presumed innocent. It is his right to an arraignment, and it is his right, presumably, to waive it. But in terms of the optics of it, it's really hard to reach any conclusion other than the fact that, had this not been one of the world's best golfers on his way to warming up for the tournament, this case could have turned out far differently. I mean, imagine that rather than Scottie Scheffler, it was a black prep cook worried about getting his French fries cut for the day, and he kept going. And
Yeah, well, I don't,
so
I would just argue that, I hear your point, but, I don't know that we have to bring number one race into it or anything other than sort of the position of influence that would be relevant to a determination of who did what, why, and what risks are, were recognized and tolerated versus weren't recognized and were thus recognized only after an arrest was made. My point here is that, Scottie Scheffler is making decisions in the interest of Scottie Scheffler because his performance on the day in question is far more highly scrutinized than the prep cook that you sort of imagine there, Norm. And therefore, the prep cook is not making any additional is not moving expeditiously around a traffic detail that is set up by the police in order to simply get to the prep cook duties for the morning.
I get it. Context matters, but principles matter more. And
I
equal
understand,
treatment
except
before the law does. And this bothers me. I mean, I think that, I don't watch golf. I think I've seen it on TV before, and it's a nice thing to do when you're looking for, help to take a nap on a sunny afternoon. And I did see Scheffler win one tournament, and it was exciting and dramatic. Um, but this isn't how people typically are treated when they've had a violent confrontation with a police officer. And, you get the impression that there's a caste system, and that if you're
yeah,
high enough
I
the
really
pecking
think
order,
you're
you're going to get a slap on the wrist.
Yeah, I don't know. I see this really, and this is no disrespect to the law enforcement profession. I think there are plenty of people here watching that know where I stand on that topic. However, I do think that, sort of the fact that it was reported by the Lexington Police Department that the $80 pants were damaged beyond repair, in addition to the minor scrapes and bruises, means that sort of the violent, like whatever this is, Norm, is being vastly overstated. What this was, in my humble opinion, right, and we'll see through the trial, but what this was somebody who has tunnel vision on what they need to be doing. There's a lot of scrutiny and pressure on what they're doing, and expectations, both, self-created and that of the environment, getting to where they go, like making very direct and linear decisions to get to prep, and then an officer that was unwilling to yield, even if the officer recognized who it was, and then sort of the being knocked down and scrapes and bruises and messed up pants, right? It's sort of that's something to justify the arrest and everything else. I'm not saying that officers need to be bumped over and bruised and knocked around and not respected, or the integrity of their position overlooked. I'm saying that the best they can do right now to justify the treatment of putting Scottie in handcuffs and him having a mugshot being widely circulated on the internet right now is to say that there was some sort of damage on that. And I understand people are like, hey, yeah, it needs to be more egalitarian. We need to stand on principle, blah, 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 blah. And I think Dawn even said other golfers were walking, miles to the course. And all I'm saying is not all these other golfers are Scottie Scheffler. Right.
No, but that's my point. And that, not that's like saying that not every person who falsifies a record is Donald Trump.
That's the real question, Uncle Pat.
Some people should, yeah, I know some people should get special treatment under law. I mean, look, I have enormous sympathy for cops. I've spent the first 10 or 15 years of my life attacking them in federal civil rights suits for their decisions on the street. And what I learned is I could never do the job. I mean, it's a tense, evolving, uncertain environment where their lives are constantly on the line, and they're asked to make split-second decisions in the face of the unknown with due respect for the rights of strangers while worrying about their own lives. I don't think it's too much to ask in a street confrontation for a person to give an officer the benefit of the doubt. And
Sure.
if you have a beef with what an officer is telling you on the street, take it up in a courtroom. From time to time, I get stopped because I'm on the cell phone on my phone, and a cop will stop me. And every time I do, I put the phone down. I put my hands at 10 and 2 on the wheel, and I ask the officer for permission to move my hands when he asks for license and registration, because I know that motor vehicle stops up there with domestics are the most dangerous stops for cops. People feel offended. They feel the police are intervening. There's no reason for it. Just listen to me, officer. And the officer doesn't know who he's talking to. Give the benefit of the doubt to the guy with the gun whose job it is to keep public order, and take your disputes to a courtroom. And if you're Scottie Scheffler and you're going to be late for your tee time, oh, well, police are investigating a death, Scottie. That's more important than your score on the golf course that day.
Yeah, and I guess I would I can counter with the same sort of contextualized, sort of sympathetic characterization on Scottie's side as well, because we're imputing a lot of ill will, or sort of we're sort of maligning his character by assuming that he was doing this in it, just sort of embracing this aura of you know what I mean. And there isn't evidence to say that, just as there isn't evidence to say that what you were saying isn't the correct take. All I'm saying is that if they are there to secure a crime scene, and there are other golfers that have gone around and through this this traffic detail, and there are other eyewitnesses that are being reported as having seen at least conflicting signals that there is the benefit of the doubt that it's not just this sort of elitist caste structure driving this whole saga. And it's unfortunate that the Lexington Police Department is going to have to air its dirty laundry because one of its officers was a little too fervent in their pursuit of making sure a vehicle didn't come too close to the crime scene.
So God has spoken, dog backwards. I'm just paranoid and have a ponytail. That's it. You're right, dog. Or you're right, God. And you should know. The thought occurred to me the other day. Maybe it is time to get a haircut. So I might surprise all of you one day and come on the air without a ponytail. We've got a little bit of time today, and we did promise a discussion of the use of lethal force in the search of Mar-a-Lago and the search for classified documents. I've never seen a document shoot back. And I doubt seriously.
There's your clip.
Many years ago, we had a client who was involved in health insurance, and the feds and he had a long-standing dispute about the nature of certain decisions he was making. So one day, federal officers in raid jackets issued a warrant and searched the man's premises for documents, and they did so with guns. And whether the guns were drawn or displayed was an open question. This man was so outraged, he asked us to challenge the search as unreasonable because of the display of lethal force, and he had the funds to do the following. We sued the head of the Internal Revenue Service, the head of the Internal Revenue Service Criminal Division, and somebody else. We served them around the country one morning. And we brought an action in the United States District Court for the District of Connecticut saying that the demonstration and willingness to use lethal force in a document search was per se unreasonable. And the Justice Department sent a lawyer in from D.C. to argue that the officers were entitled to qualified immunity. Because no case said that was unreasonable. And the judge said, no case has to say that. It just is. And it was a beautiful moment in court. I think, the story I read, said officers went armed. They were told how to dress. And apparently there was no prohibition on the use of lethal force. I think it's unfortunate I think it's fortunate that no one resisted and that there wasn't, because that would have been an amazing story if federal agents looking for documents in Mar-a-Lago shot a resistor. The use of lethal force by police officers is governed by a Fourth Amendment standard. And they can use lethal force when necessary to overcome an imminent risk of threat or serious physical injury to themselves or others. There is something called the state-created danger doctrine, though. You can't create the danger and then shoot your way out of it. It's sort of like the initial aggressor problem. Let me try it in English. Like the initial aggressor problem in a common law self-defense case to the charge of murder. It's certainly a bad look that there was a policy declaration that lethal force could be used when necessary. I'm not sure that this was a particular policy direction initiated or directed to Mar-a-Lago, or whether it was just a general statement of DOJ policy. The fact of the matter is that the state, the government, in Max Weber's terms, has a monopoly on the legitimate use of force, and the government, unlike private individuals, is justified in using deadly force to overcome resistance in certain circumstances. I would have thought a better way to handle this case would be to rule out deadly force, and if there was a standoff, to stand down and get involved in negotiations so that we'd avoid a Waco-like moment where the federal government is shooting because it can. This does reinforce, the perspective of those who claim that we're involved in high-grade lawfare against Donald Trump. And I'm sure that there are a lot of talking heads on the air today saying, the government was ordered to shoot to kill if they didn't get documents that they wanted. Who kills over a document? Nobody did. I'd need to know more. But in terms of lethal force, this is one of the things that that makes me very, very, very cautious when I deal with law enforcement on the street. They don't know
Yeah.
what they're looking at, and you don't want to be the guy that gets shot by mistake.
So our boy A.R. Hoffman for the New York Sun wrote about this, and as part of that, we have dueling briefs on this issue before Judge Cannon. I'll see if I can pull those briefs, Norm, and maybe you and I can maybe we each take a brief,
Yeah,
maybe,
that'd be fun. That'd be fun.
and then talk about it tomorrow. I think that would be fun. But just a quick teaser here. Um, A.R. Hoffman writes, quote, Mr. Smith's 29, talking about Jalapeno Jack, Mr. Smith's 29-page response aspires to persuade Judge Cannon that the government handled the evidence it collected in an appropriate fashion. The 45th president accuses Mr. Smith of spoliation, and the special counsel has admitted to providing the judge with an inconsistent account of the state of the secret documents. He did not address that issue on Tuesday. The special counsel writes that, quote, investigation in this case adopted a measured and graduated approach in the face of, quote, obstruction and deceit from Mr. Trump and his Camarilla, whom he accuses of stashing more than 180 classified documents at Palm Beach. Mr. Smith maintains that Mr. Trump, quote, identifies no plausible basis to suppress the fruits of the FBI search. So this will be an interesting little exercise that you and I indulge here, Norm.
Yeah, let's do it. Dawn McNeil, I love Dawn, and my heart aches sometimes when I see her comments. And this is one that makes my heart ache. Again, this lethal force issue is just one little tree in a forest of corruption. Yes, the DOJ is politically corrupt. It's obvious to me. I just don't know what to do with that. To suggest that a principal agency of government is politically corrupt is to suggest that somehow it's illegitimate and that its actions across the board are to be questioned, not respected, and perhaps resisted in the name of legitimacy. Who does the resisting? I was in federal court last Friday in Washington, D.C., entering a guilty plea. Not me, my client was a 3%er related to January 6th. And the rhetoric that supported his conviction was far more shocking than the rhetoric used by the Proud Boys. It's time to prepare to lay down our lives. It's time to take back our sovereignty. It's time for civil war if necessary. And when this rhetoric was read in open court, it had a sort of chilling effect. And it made me think like, John Locke is on sale in every decent bookstore. But do we really believe that we've retained the right to resist? And have we not stopped to read the caution that Locke reflects when he talks about the appeal to heaven? If you're going to resist, be sure that you win, because if you don't, the sovereign retains the right to crush you. And there has to be, in my view, some alternative to violence and violent rhetoric as a way of working out our differences. I don't think that the Department of Justice is perfect. I fight with it all the time. But neither do I think it's so corrupt that I can't trust a thing that it does, because if I did, I wouldn't be going to court to resolve my clients' disputes. I'd be hiding them in the woods and resisting the efforts of corrupt government, like Robin Hood, resisting them when they came into Sherwood Forest to take my people into custody. I still think our institutions reflect common norms and values, and I think we're struggling to define them in politically wrought times.
Man, we've got a ton of great comments. I wanted to quickly jump back, and maybe this is a pot shot, Norm. I'm sorry for shifting gears so quickly, but Jackson Barrett over on Rumble added this detail that I'll need to verify, but Jackson typically comes to the streams armed with good information. He says, in reference to Scottie Scheffler, that he was driving a designated tournament courtesy car during this accident. So adding to a little bit of the issue related to the officer's entanglement, which I think supports more of my perspective on this.
It doesn't, though. I mean, the courtesy car doesn't say, it's not diplomatic immunity from lawful process. And
in terms of, it's
much
like
a sports star may want to think it is.
Today's theme is unforced errors all the way around, right? Today's theme, I guess, is unforced errors.
All right. Well, anyhow, Dawn, why do I think you're for violence? I don't know you, Dawn. I know you through your comments here, And I know you to be a retired sociologist and a very thoughtful woman. And I enjoy your comments more so perhaps than anybody's that I read, because I know they're informed by a commitment to a scholarly literature that I sort of understand some days and don't understand at all others. My fear, though, is that this delegitimizing rhetoric leads to violence. And so I don't think you're calling for it. I just ask people to be careful about what they wish for. My nightmare about the United States is that we're talking ourselves off the edge of a cliff, and once we get to the bottom of it, we're not going to know how to get back up top.
Like and subscribe at LawPod Daily. Our viewer count today is temporarily lower than it normally is because I need to finish registering our stream for Google AdSense, which is how we get paid for all of the viewers. So I'll get that done today. Got to get the EIN number and all that kind of stuff loaded in so that we can tell on ourselves to the man come the appropriate time, Norm. But in the meantime, if you're watching this now, you better have already liked this stream, but there's still time. And make sure you're subscribed. If you're over on Rumble, we're Law and Legitimacy. If you're on X, we're at LawPod Daily. And if you're here on YouTube, we're at LawPod Daily. We're here every morning, 8 a.m. Eastern time. Most mornings. I've been a little more active in the courtroom here lately and unexpectedly. But Monday through Friday, 8 a.m. Eastern time. No way. We're not doing the ponytail snip. Don't do that.
I might.
Here on Rumble, YouTube, and on X. And also, we're on podcast channels. So wherever, you get your podcasts, Apple, Spotify, Google Play, Overcast, wherever. AMF Yo-Yo is the hashtag. Norm, maybe it's time we reintroduce that acronym. Maybe not. But Audios MFers, you're on your own if you didn't know.
AMF. Talk to you tomorrow, folks.
See you tomorrow, Norm. We'll do that dueling brief review.
Yeah, send that over. That'd be fun.
I'll do the search here, maybe over lunch today, and send it to you. But anyway, thank you, everybody, as always. Norm, see you tomorrow. AMF Yo-Yo, LawPod Daily, all that good stuff. See you later.
Ciao.